about what you want to talk about and what's on your mind than what's on my mind. So I hope that you're not bashful about asking questions. So with that, Justice Edmunds.
Oh, thank you very much. And it's really nice to be up here and see all of you folks. Thank you very much for coming. I'm at High Point, as Louis mentioned, which is brand new. They had their first Federalist Society meeting early this week. And Judge Ho, who's on the Fifth Circuit, was their speaker. So I'm flattered to be here. I want to start my remarks by acknowledging that there is no best way to pick judges. Every system has its advantages. Everyone has its pluses and minuses. But ultimately, I think elections are an effective way of bringing good judges to the bench. And believe me, I'm here because I lost my last election. I know they're not perfect, but years of experience have taught me that they have their value. Earlier in my career, like Judge Kirsch, I was also a United States attorney, which is a presidential appointment. And that's a limited one. You know you're going to lose the job eventually when the president changes. And the U.S. attorneys usually talk among themselves, what do you want to do next? Many of us had judicial ambitions, and we would talk about how's it done in your state? And hear all sorts of things: gubernatorial appointment, merit panel selection, some form of the Missouri plan, legislative selection, partisan elections, nonpartisan elections, election and retention, appointment and retention, probably others. But everybody said, I don't care what you call it. It's really political. Merit's a factor. It always is, and it should be, but it's only one among many. Now, elections, of course, are political to the core, but if you look at some of the others, you'll see that they have their political ambition aspects. You can be the best lawyer in the state, but if you don't know somebody in the Senate, you might have trouble ever getting a federal appointment to the bench. In an appointed state, it's good to have the governor's ear or somebody in the governor's cabinet who has the governor's ear, that sort of thing. Merit selection state, you better be friends with somebody who's on the merit selection board, know a member or two of that. If your area has a political machine, you need to be part of that machine. And in one of those states that have legislative appointments, guess what almost all the judges in that state have in common? They're alumnuses of the legislature. So these things are political. Acknowledging that, I'm comfortable with elections. Every election I've been in was statewide, and that's not the case in every judicial election, but that was my experience. And with all that travel, it gave me a lot to chew on. I've run in partisan races. I've run in nonpartisan races. I've run in publicly financed races. I've run in privately financed races, and I can give you chapter and verse on what's good and bad about each. But my first and major reason for liking elections is I never would have had a chance to be a judge in any other system. I don't have any family ties. The only direct family relation that I could find who'd been a lawyer was my great-great-grandfather, who was a Civil War veteran. I don't have any friends in the governor's mansion. I don't have any buddies in the General Assembly. I was in the wrong party back when North Carolina was a one-party state. And an election gave me a chance to make my case to the voters. This is what I am. This is what I do. And I think every lawyer who has judicial ambitions should have that opportunity. And I have other reasons as well. Elections give voters a say, and that's fundamental to our democracy. I know judicial elections are different and judges are different, but in my experience, citizens really cherish their right to vote. It's both its symbolic value and its real value matters to them, and that includes judicial elections. And elections are a real civics asset. I think we all mourn the loss of civics education in high schools. Most people graduate from high school without knowing much of anything about what we mean when we talk about the rule of law, without understanding that judges are independent of the other branches of government. Candidates can take up some of that slack. Those who want to be judges in an elective system have to get out and tell the public what judges do. And sometimes that's all the citizens hear. Newspapers are, of course, dead. Most of what they're getting, people out in the real world, getting it from social media. And we've seen this week just how dangerous that can be. So judges, the judicial candidates carry weight when they go out and then talk to people. And I also believe that the real life experiences that someone who takes the bench has had before and while they're on the bench broadens them. Campaigning means, as a candidate, that you have to go and worship at churches where you don't normally worship. You have to go to events that you normally wouldn't go to. Heck, when I was preparing for this, I reminded myself, I was in a cow milking contest. There are all sorts of things candidates. So you go to events where you know you're going to get a chilly reception at best. Affinity groups of lawyers who don't like the type of law you practice. You know they're not going to be happy to see you, but you need to hear from them and they need to hear from you. So campaigning can really open your eyes and in some ways open your minds. Another thing judicial elections do is they flush judges out of their chambers. Having been a judge as long as I was, a total of 18 years, I know you're going to find this hard to believe, but people have told me, you're the best judge on that bench. You're the smartest judge on that bench. You're the best writer on that bench. You're the best looking judge on that bench. If you're not careful, you start to believe that stuff. If you get out, if you get away from the lawyers, if you talk to people, you're going to run into people who say, I read that opinion and you were wrong. It's no fun, but it is a valuable antidote to black robe fever, something I think we're all familiar with. So thank you. It's welcome. So let me get a swig. And getting, I disagree with Judge Kirsch on one thing. The bar itself can be very valuable in this process. In our elections, especially on the trial level, the lawyers know who the good judges are and who the bad judges are. And as a lawyer, before I took the bench, every election people would come up and say, who are the good judge candidates? If a lawyer says, that's a bad judge, get them off the bench. That's the easiest way to do it, and it works. I have seen bad judges lose elections because they took themselves too seriously. My experience has been that voters are more likely to respect judges who have had real-world experience, who've been in the electoral trenches, who've worked for their job, who've won an election, much more than they're likely to think of someone who's on the bench because they practice law with the mayor. And I'm not really arguing against the other systems. There are great strengths to the other systems I mentioned. And, so I'm just talking about the ones that I think works well. In these discussions, and I've been in others, there's often this underlying sense that judicial elections are kind of icky, that there's something just, undignified about judges going out and asking for votes, that selection is a more pure process. No, it's all politics. It's just where the politics is going to surface. And to swap judicial elections for some other system of appointments is just to move the political aspect around and swap one set of benefits and drawbacks for another. My point is not all systems are bad. I've kept my phone just in case the White House calls with an appointment. I want to be ready. But I think elections are consistent with our democratic, small d, principles and have gotten us good judges. I'll close with this. I've gotten a phone call in my career from a senator telling me I was going to be appointed a U.S. attorney. That was a good day. And I have sat up all night watching the votes come in, watching how they turned, seeing that over 1 million people wanted me to serve on the North Carolina Supreme Court. That was a great day. Sarah Parker, who was a Chief Justice on the North Carolina Supreme Court that I served with for several years, said, the courts belong to the people. And she's right. Thank you.
Thank you. thank you very much, Justice Edmunds. We're going to turn it over here to Justice Kelly in a second, but I have one observation. I often tell people that want to be judges, and this is well before I was a judge. This is when I was at Winston-Strawn practicing law. I wasn't all that involved in politics, but I knew some people in Indiana. And I used to, my friends would say to me, I want to be a judge. I want to be a federal judge. What do I do? How do I become a federal judge? And I would tell them all the same thing. You only need to know one person. You just have no idea who that person is. You may know the right person and you may become a federal judge, and you may not know the right person and you have no chance to becoming a federal judge. So anyway, we're going to turn this over to Justice Kelly. And we're going to hear some great points, I know, from Justice Kelly. But here we are in the greatest democracy in the history of the world, and we're going to argue that justices of the state Supreme Court, right, should not be elected by the people. And just as you think about this, when you think about states, okay, especially now, the governor has a lot of authority. The legislature collectively has a lot of authority. Individual legislators typically do not, unless you're sort of the Speaker of the House or the Majority Leader of the Senate. I don't think in any states, even in Illinois, I don't think they're full-time positions. These are folks that do other things and come to the legislature a couple of times a year. And some have no background in legislating or in the laws that they're passing. Collectively they do, right? But individually they don't. So the justices of the Supreme Courts of the states hold extraordinarily important positions. So Justice Kelly, let's hear why they shouldn't be elected.
Thanks so much. Well, thank you, everyone. It was great to see all of you. Thank you so much for the invitation. I was thrilled to have an opportunity to come out and speak with you about this interesting topic. Thank you to Justice Edmunds and you, Judge Kirsch. It's great to be up here with you. Now, what you've heard from Justice Edmunds is the best case for an elective system. And Justice Edmunds is probably personally one of the greatest reasons for recommending an elective system, because it produced him. It's also one of the worst because it removed him. So let me do this. I'd like to make 3 points. One, that the work of the judiciary should be insulated from politics as much as humanly possible. Two, that the process of the judicial task is something that is completely incompatible with politics, and the process of staffing the courts should complement and reinforce the judicial duty, not detract from it, right? And then third, and this is going to sound bold, only because it kind of is, but the third point is the general population is not equipped either by training, experience, or disposition to select members of the judiciary without reference to politics. So let's start with this. The idea that the work of the court needs to be insulated from politics. And I'll quote from the Massachusetts Constitution of 1780. And they said, it's essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will allow. That's a strong statement that you want to be insulated from politics. But let me take a couple of minutes to explain why that is critical. It's not a matter of preference, it's a matter of structure and the nature of the work that the judiciary does. So now, I know you all know about the separation of powers, so I know I'm not telling you anything new about that, but I'm going to ask you to look at it perhaps from a fresh perspective. I want you to look at it in temporal terms with respect to what each of the branches do. So we've got the legislative, got the executive and the judicial, and we've got future, present, and past. So let's look at how those match up. The legislature takes for itself responsibility for the future. It peers into the uncertain, unknown tomorrow to figure out what laws are necessary to promote human flourishing, right? And it's an incredibly political process because their job is to condense and consider all the hopes and fears and ambitions and values and all those other things that go into the thing we call politics and distill that down to a law, right? And that law controls tomorrow and every tomorrow after that until the legislature changes it or rescinds it. So the legislature deals with the future. The executive deals with the present. The executive's job is primarily derivative of the legislature, right? If we look at, and you'll find this in state constitutions as well as the United States Constitution, the job of the executive is today and every tomorrow as it becomes today to take care that the laws are faithfully executed. Now, there's some discretion in the way the laws are implemented, and so it too is a political function, and you have to take account for all of those powerful competing views and wants and desires of the population that you serve. So that's political too. And then you get to the judiciary. The judiciary deals with matters of the past. And with respect to politics, that changes everything. And here's why. When you deal with the legislature, you're dealing with questions of oughtness. We have a broad array of discretion about the laws that we are going to adopt. And the question is, which one? What ought our laws to be? And you're free to pick from that whole potpourri of possibilities because it hasn't yet become instantiated yet. So you can deal with the question of oughtness. What ought our laws to be? How ought the laws promote human flourishing? Same thing with the executive. You deal with a more narrowed, cabined discretion in politics, but still the question is, how do we implement this law in a way that promotes human flourishing, right? It's still political, but it's narrower, and it still deals with oughtness. It hasn't yet come to be. And so we can say, I've got options in front of me, and which one of them ought I to choose in doing the duty of the executive branch? And that's not open to members of the court. So when we look at the work of the court, I like to think of it as kind of like an archaeological dig site, right? So you're going back into the past and you're looking for two things. Just like an archaeologist looks for artifacts, we're looking for artifacts too. Except the artifacts we're looking for are facts of the case, right? What actually happened. And then we're looking for the law that existed at the time those facts happened. And it might not be the same as the law today because the legislature's always out there doing its job and passing more laws, right? So the law today might not be the same as the law that existed at the time the facts of the case took place. So your job as a jurist is to uncover the facts and the law. And then here's your duty. You apply one to the other and you give your judgment about what the law says about the facts. Now, what's missing to that? There's not a range of options. No one's interested in your thoughts about what the law ought to have been back then. Not interested in your thoughts about what the facts ought to have been back then. Those are beyond our reach. They exist in amber in the past. They cannot be changed, and they are impervious to oughtness. You have no choice but to deal with the law and the facts that existed. Now, a good archaeologist makes sure that he goes into the dig site and he doesn't bring any detritus of today to litter the dig site. Because if he did, he might find some artifacts from the slice of time that he's investigating, and he might confuse it with the detritus that he brought in from today. And what would result would be a useless chimera of things of yesterday and things of today that are incapable of telling him anything about the past with any accuracy. Same thing with judges. If you bring in your personal ideas about politics, about what the law ought to have been, what the facts ought to have been, you're littering the dig site with things that are not relevant to the work. And if you allow those politics to influence what you do, what you will come up with is a useless chimera of an opinion, because it doesn't tell you anything about what the law said about the facts. What it says is, there's the law, there's the facts, and my personal opinion. And I cobble something together out of that. All right? So that's why politics has to be insulated away from the judiciary as much as the law of humanity will allow. All right, so here's the third point. The general population is not equipped by training, experience, or disposition to select jurists without reference to politics. Let me just give you a little bit of an example from my own experience. My race in 2023, which from my perspective, but not others, failed spectacularly. 1.6 million people came out to vote. We have 16,000 or so attorneys in the state of Wisconsin. Now let's look at what you ought to be considering when you're voting for a jurist. Right? Their facility with the law, their understanding of the structural aspect of the Constitution and its individual provisions, your respect for the litigators that come before you with their cases. And so how do you find out about this kind of thing? Well, you read the opinions that they write. You watch the hearings they conduct. Huh? So let's go back to those 16,000 lawyers. I don't know that all of them voted in my election. I doubt it. But let's say they did. And let's say that these lawyers, the ones who understand the law the best out of that 1.6 million, let's say they all read my opinions. And they read my opponent's opinions. And they watched the hearings that we each conducted. And then they decided, I will support Justice Kelly or his opponents. That would be an informed vote. And let's say all 16,000 did that homework before they went to the polls. That would mean that 1% of the electorate based their decision on relevant information. Because the other 99%, I can tell you, they're not spending their evenings reading my opinions. Now, I think they're really well written, and I think they're good reading. But I can tell you they're not doing that. And they're not looking up WIS-I to see the hearings that I've conducted. They're not doing that. But they still voted. So what do they base their vote on? If they're not basing it on an evaluation of my facility with the law and my commitment to the Constitution and my respect for the litigants and the way that I conduct myself in chambers, on the bench, what is it? Well, they're going back to what they know. What they know is politics. And that was confirmed in bold capital letters in my 2023 election. So I ran what must have been the most boring judicial campaign in the world to the general population. Because what I like to do, and I actually enjoyed campaigning, talking with the people of Wisconsin. But what I do, I would go to them and I'd say, well, here's the office. Here's what the responsibility of the office is. And here's the way I conduct myself in that office. And so I talk about the proper role and function of the judiciary in a constitutional system and why it's not about politics and it's about the law and, you know, the archaeological dig site. And I get done and they come up to me afterwards and they say, Justice Kelly, that was interesting. But where are you at on the issues? Well, I just told you where I'm at on the issues. The issue is, do I know how to handle the law? Am I committed to the Constitution, its structural natures and its individual provisions? Those are the issues. No. That's not what we want to hear about. I hear this time after time after time. Now, my opponent was not as freighted with concern about not involving politics in her campaign, and so she campaigned openly about her politics and described in vivid detail how she would deform the Constitution to get to the results that she wanted. I mean, I remember when our first appearance together was in front of the trial lawyers of Wisconsin. It was not a friendly crowd for me. But I did my standard pitch, and she came. And I won't say specifically what the issue was, but she says, "Well, I'm going to tell you about my values," and she launched into her political positions. And on one in particular, she said, "Now, the due process clause of the Wisconsin Constitution hasn't gotten enough attention to develop its forms and applications to get to this issue that I know that you care about. And I'm telling you that when I get there, I'm going to make sure to put in the work to make sure that the Wisconsin Constitution's due process clause covers this issue that you're concerned about." And I looked at her and I was just gobsmacked, because the provision of the Constitution she was referring to does not exist in the Wisconsin. It's kind of an odd happenstance. There's an historical reason for it. But Wisconsin's Constitution does not have a civil due process clause. And there she was, I'm going to make this up out of whole cloth to get to the political end. This is the problem with an elective judiciary. It is not matching the method of selection with the responsibilities and duties of the court. It is detracting from it. It's not complementing it or strengthening it. It is weakening it. It is telling us that we are going to have politics in the courtroom. The total spend in my 2023 campaign, by all sides, outside groups included, was $50 million. It was the most expensive judicial race in the history of the country, not just Wisconsin, the entire country. Now, I can tell you with a fair amount of confidence that the people spending that amount of money, either in support of me or my opponent, was not interested in banal questions like, well, does this case controlled by section 12.1 sub A sub 1 or sub 2, right? Most of the work of the judiciary is making distinctions between sub 1 and sub 2 cases. At the end of a judicial career, this is the body of your work, accurately making those distinctions faithfully to the law that it exists. And there are, in the general population, there is no one who is interested in that. And yet that is the body of our work. It is our duty. It is our responsibility. And even in the best case scenario in 2023, 1% of the voting public based their decision on relevant information. That is to say, 99% of the people who voted in that election based it on something that is no more relevant than my favorite color. This is why elective judiciaries are problematic. Now, I agree with Justice Edmunds that there is no perfect system. The goal is to squeeze politics out as much as you possibly can. But if you squeeze it all out, we'll all be dead, because there is no possible way of separating us from politics. There are ways of controlling for it. I think the founders had it right, the framers. I think they had it right in the way that they set up the system. Let's look at the way the Constitution was originally structured. Only 1/2 of 1/3 of the federal government was popularly elected. It was the House of Representatives. You know how much the House of Representatives is involved in the selection of federal judges? Not a bit. The framers looked at that and said, this is what we're going to do. We're going to exclude the popular sentiment as much as we possibly can, right, from the selection of the judiciary. Remember why the House of Representatives has a 2-year term. Remember why? They built the House of Representatives to capture the passion of the population. And they knew what about popular passions? They pass. 2 years from now, there's going to be a new popular passion. The judges, they're going to be on the bench for the rest of their lives. The goal is to avoid allowing that popular passion to influence the selection methodology. And so today, even today, in our hyper-polarized world, and the selection and confirmation of Supreme Court justices for the United States, you will hear even Justice Elena Kagan in her confirmation hearing say, what? We're all originalists now. And did she talk about her politics in her confirmation hearing? No, she did not. Because she knew she was in front of a body that was equipped by training and experience and disposition to look for the proper qualities in a jurist to put into a position where there's going to be lifetime tenure. Is it perfect? Absolutely not. Are there people on the Supreme Court today who let their politics run away with them? Yes, yes, there are. But is there the possibility of getting someone on the court who won't let their politics run away with them? Yes, yes. And that is the signal advantage to the federal system. It makes it possible. In an elective judiciary, you're going to have politicians. You are inevitably going to be drawn in to political discussions, political points of view. It's what the population wants to hear. And they're not going to watch ads that would tout the proper judicial function, right? I mean, can you imagine that? The ads, they almost write themselves. Justice Daniel Kelly, protecting the world for section 12.1, sub 1, sub 1. I'm Justice Daniel Kelly, I approve that message. We're going to get politics in the courtroom. We're going to get it more often with an elective judiciary than with an appointive system. That's why, notwithstanding the fact that an elective system brought us Justice Edmunds, I still favor the system found in the United States Constitution.
All right. Thank you, Justice Kelly. Justice Edmunds, I want to give you a chance to respond, but I want to ask a specific question that maybe you can think about. You know, when I was going through the confirmation process, I was asked by someone in the White House, what would you think if the New York Times wrote an opinion? You know, I wrote an opinion on a controversial issue, and the New York Times wrote an editorial, or there was a columnist for the New York Times, the Washington Post, that wrote an article or wrote a column trashing you. And I kind of said, I don't read those papers, so I don't care. But actually, I do read those papers. But I said, well, why would that be? What difference? What's the question? I don't know what the question is. Why would that possibly bother me? You know, I said, as a lawyer, people have said nasty things about me. It doesn't bother me at all. Okay, I mean, you can just get used to it being a lawyer. But I said, why would I care as a life tenured federal judge what the New York Times thinks about me? I'm not going to be impeached. Okay, I'm just not. What would I care? And so I think about that in terms of politics as you're approaching a re-election campaign, or you're approaching the election. Does it affect? And you know, think about it in terms of an appellate court judge who's going to run for the state Supreme Court, or a state Supreme Court justice who is running for re-election. do politics creep into judicial decision-making in a way that it wouldn't earlier in a term or than it shouldn't?
Well, it's hard to answer that question generally. I think, we are elected judges. We're aware of the calendar very much. But going back to when I was a U.S. attorney, I had to, have those quiet moments with myself when I said, if I take this case or a particular case, or am I willing to take a case that could mean the end of my career? If the answer, in other words, might I have to pursue a corruption case against a senator who recommended me to the president? If the answer to the question is no, I would not, I'm not worthy of the job. I should not take it. The same thing is true for a judge. I mean, this is very easy to say in this context, but a judge has to be able to say, am I willing to write an opinion that I believe in that might cost me the election? If you can't say yes, you shouldn't be in the game. I agree with a lot of things you've already heard so far about the problems of different types of systems. It's sort of like trying to squeeze a balloon, politics and money is. If you squeeze it out in one area, it's going to pop out in another area. And the decisions that we need to make are really how best to cabinet. But, I'm keeping this short. We know the horror stories. I remember watching and reading about the Wisconsin election. I didn't realize we'd wind up on the same stage together, but boy, I felt for you. But on the other hand, we've seen the federal system produce the Bork hearings, the Clarence Thomas hearings that destroyed people. That's no panacea. We've just got to keep working the issue and working the issue as best we can. But I think it's fundamentally anti-democratic, small d, to say, we'll turn this over to the elites and let the rest of you little people deal with the consequences.
All right, thank you. Justice Kelly, I have a question for you. Should this be a debate about term limits? And let me tell you what I mean about that. You made the point, which I think is very important, that judges should be insulated from the political process. If there were term limits, would that have that effect? And I ask this from this standpoint, either life tenure. I mean, you all know that in the history of our country, there have been Supreme Court justices who have been appointed who one party would believe that they were going to rule a certain way on certain issues, and they turned out to be wildly wrong, okay? But that is totally insulated from the political process, right? Because you have life tenure and you are totally insulated. What if state Supreme Court justices were elected for life, or what if they were elected for 1 10-year term? Now you'd have a situation where you'd still have this populist appeal, right? You'd still have I think I'll just rephrase what you said. You're going to have a lot of people going to the polls to vote for the D or the R,
Yeah.
right? With absolutely no clue what the person represents or who the person is or what the person stands for, no matter how much money is spent, right?
Yeah.
But if they were elected for a 10-year term and unrenewable, would that help remove some politics from the system?
I don't think it would. Now there is a term limit or maybe lifetime tenure that would mollify it a little bit, but only on the back end. So if you have an elective judiciary and then you have let's start with a lifetime tenure like a federal judge. Well, then you're just setting the problem concrete, right? So that's just never gonna change. If you have a term limit, let's say 10 years, and non-renewable after that, you still have it. Frankly, it depends on the age of the justice at the time he's elected. So one of the problems you can run into, you have a young justice, maybe elected in his 40s. And you go into the state judiciary. State Supreme Court does not pay quite as much as they pay the circuit court judges.
No.
And there's no pension. There's no guarantee. So at the end of your term, you're 50 years old, you're 60 years old, and you've got 20, 30 years of work left to do. Towards the end of that term, you're going to be casting a weather eye out there amongst the law firms, other potential employers, making sure you're not getting them pissed off, because you're going to want a job once you get done, right? So I don't think that fixes the problem, because it moves it, and it takes a different form, but it's not going to insulate the jurist from that kind of influence. And they do, and sometimes in their candid remarks, it's incredibly revealing how much this affects them. I won't say which of my colleagues said this, but in discussing one of the cases after having heard oral argument, we were in conference to decide the case, and I said, well, this is how I see the law lining up, and my colleague looks at that and she says, yeah, this seems about right, but I can't do that. I'll get roasted by this group, that has played a high profile in her election. Just came out and said it. I can't do that because I'll get roasted. And while agreeing with me on the analysis of the law. So anyway, you can cut and paste where the problem is going to crop up. But if you start at the beginning by allowing politics to decide who's there, cutting off their term of service isn't going to fix the fact that they came there as more than likely, Justice Edmunds as an exception, more than likely came there as a political actor more than a judicial actor.
All right, I'm going to come back to you in a second with
All
another
right.
question on that. But Justice Edmunds, I have a question for you, and it has to do with candidate quality. Okay, in elected. I was a lawyer at Winston Strawn, working at my desk one day, and I liked being there. Someone called me a very influential political figure in Indiana and said, will you run for the Indiana Supreme Court? And I said, absolutely not. And it was not, Indiana has a sort of a hybrid system where the governor makes the appointment and then you run for retention shortly after that. So it's not an election like your election, but you're still on the ballot. I said, absolutely not. And they said, why would you not be willing to do that? I said, well, I need to go through this very public selection process because I first need to apply for the job. And then the nominating commission does interviews, and the interviews are public. And what am I supposed to tell my clients? I actually have clients that I care about, and am I going to tell them I'm more interested? And then when the next piece of litigation comes, are they going to continue to hire me? I don't know. And then when I got a call several years later and said, would you be interested in being the U.S. attorney? I thought, well, this I actually can do, because nobody's going to know that I'm even interested in being the United States attorney until there's a press release from the White House saying that I was nominated to be the United States attorney, and I will be confirmed. U.S. attorneys typically, until recently, U.S. attorneys typically were not nominated if they couldn't be confirmed, right? That was the standard that we went. There was an FBI background check. Most U.S. attorneys were extraordinarily non-controversial, and if you were unconfirmable, your nomination was just pulled. Okay, but what do you think about candidate quality for these positions?
A little bit of that goes to the sort of question we haven't discussed of partisan versus nonpartisan elections. In partisan elections, in my experience, the parties would sort of vet the candidates, and there might be a primary. But generally, the party would sort of try to determine who's interested and who's interested that shouldn't be. And generally, you could be pretty sure that whether you're looking at a Republican or a Democratic candidate for judge, that person was qualified. You might disagree with one of them for one reason or another, but they had the makings of a judge. In a nonpartisan race, anything goes, and somebody can put together a campaign, and there is no one to sort of the voters themselves to say, you shouldn't be doing this. I mean, you make a very good point about how being a candidate, you know, being a candidate can affect your practice, especially if you don't win. But people, a lot of lawyers want to be a judge. You know, it's kind of nice to have people laugh at your jokes and have a good parking place and all that. But you know, we're trying to be, you know, we're pushing points of view. One of the, be candid, one of the drawbacks to election of judicial candidates is it discourages introverts. People who don't, I know people who would make excellent judges, but they don't want to get into their arena, and get bruised is almost inevitable in these cases. So, you know, again, we're looking for solutions and we don't really have them, but there are usually enough people who are interested in running for office to make sure that there is at least one qualified candidate for the seats.
All right, thank you.
Yeah.
Justice Kelly, I have one more question for you as we're running out of time here, but I have one more question for you. There are people that say that there are two positions in our government that are maybe more political than any other position. That's the position of United States Attorney and United States District Court Judge, because those positions are largely, at least, you know, until recently, okay, largely selected by the home state senators. The home state senators had their prerogative to pick the United States attorneys, and the district circuit is different, but district and United States attorney. But is there a more political body in the country than a nominating commission? And let me ask you this, and should there be, okay? And here's what I mean by this. In an appointed system within a state, there's always a nominating commission that submits names to the appointing official, whether it be the governor, whether it be the legislator, whatever. The nominating commission is set up so it's usually skewed in favor of the governor's political party. It's typically the way it works, right? 5 people on the nominating commission, 3 Republicans and 2 Democrats. Now, in my county, it was historically, where I live was a very heavily Democratic county. And we had Republican governors for years in Indiana. And the nominating commission was largely made up by Democrats. So it was a running joke in the county that they would present 3 names to the governor. 1 was competent to be a judge. 2 were extraordinarily incompetent to be judges. Okay. So the governor had one choice: pick the person who is competent or reject all 3. I'm being a little facetious. I'm exaggerating a little bit, but I'm trying to make the point. Is there a more political committee that exists than a nominating committee for selection as a state court judge?
Yeah, I think the answer to that is no. There is no more political body than that, and that can be a problem or not, depending on their authority, right? So the nominating commissions for federal positions are advisory. So they'll sift through the candidates, do the background check, blah, 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 and they'll pass up the names or not. And the president can just say, yeah, I don't like that. I'm going a different direction. Generally, they don't, but they could, right? So if there were 3 incompetent names passed up, the president could say, start over, or I know somebody, we're done. And there have been, I know a few appointments.
That does happen.
Yeah.
Yep.
That does happen. When it comes to be a problem, so I don't see that as a problem, as long as it's advisory. The problem comes in the Missouri plan, where the straight up Missouri plan, the nominating commission is mandatory. The governor cannot select anyone that is not passed up by the commission. Now, Justice Edmunds said, a lot of what we're doing is squeezing the balloon, and the politics just goes chasing another part of the balloon. This is that on steroids, because not only is it a political process to get through that kind of commission, but it's done in secret. And generally speaking, Nobody knows outside of the close-knit legal community. Nobody knows who's on those commissions and what they're looking for in the people they're going to pass along to those who are responsible to the electorate. And so what you end up with is a really kind of a recapitulation of the New Deal mentality. Remember back in the 40s, and we had the explosion of executive branch agencies and independent agencies. Remember these? The ideas that there should be groups exercising governmental power that are not accountable to anyone. I mean, it's just, but this is that kind of a recapitulation of that in miniature. We're going to get together these groups of lawyers and maybe some other members of the community, and they're not democratically elected. They're not responsible to anybody. And yet they're going to tell the governor who he might appoint to the courts. So yeah, they're really political and they're really problematic when they're in the pure Missouri plan format where they're mandatory.
All right, I'm going to ask you if you have any questions. Bob, you'll like this. Do you remember, there were a few years ago, you'll appreciate this. A few years ago, there was this debate going on. I think it was in 2020, and there were media outlets that were incensed that prosecution decisions in individual cases were not being left to the career assistant United States attorneys. Do you remember that? You remember there was a debate. The career prosecutor should be making decisions because they are non-political. The U.S. attorney is political. And I think as U.S. attorney, I could imagine almost nothing more horrifying than a non-accountable assistant U.S. attorney who you and I both knew that we wouldn't trust them to do a whole lot, right? But they're going to make decisions that have tremendous effects on people's lives, and they're accountable to who? Nobody, I think.
Well, until recently, they couldn't be fired.
Yeah, right. So anyway, does anybody have any questions? Yes, go ahead. I see a lot of questions. You're in the back. Go ahead first. You're first.
So in February, it was reported that a New York trial judge would resign after, when he got called up for jury duty, he admitted that he thought that any defendant in his court was inherently guilty. New York, at the trial court, has partisan elections serving for 14-year terms, and this particular judge who just resigned was not an attorney. He had no legal training. He just happened to be the individual that the machine chose to run on the ballot, and he got the job. Why should those individuals who have no legal experience whatsoever, a pretty false conception of the law and the legal system in this country, why should they be even remotely capable of being in a position to administer justice, especially when you think of all of the cases that you can hear in a 14-year term and all of the injustice that can be done if you truly think every defendant who comes into your courtroom is inherently guilty?
Well, it's a hard question to answer. I will tell you that in North Carolina, about the time I was in law school, we had a race for the Chief Justice of the Supreme Court, and a fire insurance salesman ran for it and damn near won. And after that, North Carolina at least said, well, okay, you got to be a lawyer, at least if you want to be a judge. To answer my position, the position I'm arguing in this debate can only acknowledge the point you're making. Crazy things happen. And that's a failure of the electorate to some extent, but I don't know, at least the judge was honest. I mean, I'll give him that.
Yes, go ahead.
Okay. I'm sorry, we seem to all be piling on you, but last year, it was November 18th, I was listening to a case online. It was a state Supreme Court case, and the justices were asking some of the most inane questions I've ever heard. One of the justices, it was not one of them, like in this case, it was across the gamut. It was an abortion case, and someone said this is a 150-year-old law. Someone said this law was made by white men. Someone said like crazy things about why this law shouldn't apply. Happens to be it was the Wisconsin Supreme Court, and the craziest judge by far was the one who beat Judge Kelly, and was sitting on that court because of that. they said crazy things with zero relationship to the law. Things like, because the law was made in 1850, why should it still apply? Justices on the court. It just seems like such a disconnect. It wasn't one of them saying crazy things. They just went down the line saying stuff like that. I can't wrap my head around the effectiveness of a system that produces a state Supreme Court that just goes down the line and says insane things like that have just really no bearing to the law. I've heard bad arguments from the United States Supreme Court and United States Circuit Courts, but they're never on that level of just purely illegal. They might be wrong in some way, but they're not illegal.
There wasn't a question mark at the end of that.
How can a system be okay that does that?
Because it's the only way most of us could get to be a judge.
Can I add to that? I think if we had folks in here from the American Constitution Society, they would say the exact same thing about some colleagues of mine on the federal bench. You know, they would say the exact same. We hear questions, we see, you know, and questioning during oral argument is totally different than a written judicial opinion. I mean, we ask questions all the time to test limits of an argument, to try to poke holes in an argument. We're often asking questions for our colleagues' benefits. You know, I mean, all of us as appellate judges, we're doing work up on the bench. I may hit the bench. I've not talked to my colleagues about the cases. So if three of us were sitting in a panel, I may be asking questions, trying to convince, you know, I think, all right, I got Justice Edmunds, I need to convince Justice Kelly. So I may be asking questions of a litigant, not trying to make a political point, but trying to show a fallacy of an argument, or, you know, what's the test? What's the principle? What's the limiting principle? So
But that's the point though, right? I mean, you're asking relevant questions about the law, so that once you're done with the argument, you can go back and you can write a cogent opinion, right? And I question how much I ought to say about my former bench, but I agree. I've been horrified. I mean, it's just. The overt nature of the political drive, right? They are not questions that are testing limits. They're not questions looking for distinctions between competing authorities. They're questions that are designed to get to a politically driven end. I mean, who cares how old the law is? It doesn't have an expiry date. That's not the way that laws work. If you don't like them anymore, we actually have an entire branch of government committed to the responsibility of repealing it.
yes, go ahead.
So, Justice Edmunds, to your point, I would concur that it's true that obviously the committees which pick people can be political, and obviously we know that elected officials and the boards which they, through surrogacy, pick people obviously can be political and at times corrupt, perhaps even. But what's unclear to me is what we gain as a society by venturing to have a society which really doesn't have the capacity or understanding of what law even is to be selecting the administrators of it. That to me is unclear. Even if we were to presume that the way Article 3 judges are selected and state level judges who are elected are, even if we presuppose that this is going to have the same political problems and perils, I don't really see what benefit we open up by having a class of population which doesn't really have the capacity to understand what they're even voting for. Just in the sense that when you vote for a senator, you are voting for someone who is a agent of the interest that you seek to have the government pass, versus a judge is not in the agency of anybody, but for the overall pursuance of constitutional objectives and upholding the Constitution.
Well, I think the argument you're making could be made about any of the branches of government, because we'd all love to have a considerably more knowledgeable electorate. But I don't know. I mean, it's my point of view that you can fool some of the people some of the time, but you can't fool all the people all the time. The Democrat, small d, Democrat view, we are a democracy. We trust the people. People fool us sometimes. poor Judge Kelly. In fact, even me, if you're looking at the right year. But I am happy to put my fate in the hands of the electorate. I am not happy that I lost my election in 2016, but I am not upset with the person who ran against me. He had every right to do what I did, and the voters had every right to pick him.
So, that's just a small point. There's a shift in the way we looked at the responsibility and participation of the general population around about the mid-19th century with the rise of Jacksonian Democrats. But that was distinctly at odds with the view that the framers had, right? So they understood. I mean, take one of the greatest exponents of democracy, Thomas Jefferson himself, and he believed that there was going to be a natural political elite, not a class, right? It's not something that you're born into, but by virtue of interest and education and experience, there will grow a class of people who has relevant knowledge to the workings of government. And this is one of the reasons why we had the structure that we do. We have the House of Representatives to capture the passions of the people, right? And so everybody participates there. And then we got the Senate, elected by the states, not by the general population. The president, elected by the states, not by the general population, because the understanding was there needs to be knowledge and experience and wisdom in the selection process itself, and that you ought not be asking the electorate to do something it's not equipped to do.
All right, go ahead. You had your.
I'll
hand
stay
up
here
for a
all
while.
night, just so you know.
My question is also for Justice Edmunds, albeit somewhat less accusatory. I understand that you want to protect democracy, although I wonder about whether democracy is an end unto itself or a means by which we achieve the framers' moral vision for the country. And I was wondering if you could speak to that with relation to this issue, because I know a lot of people appeal to democracy in the abstract, as if democracy itself is the highest ideal, whereas others would argue that democracy, like having free speech, is a means by which we achieve the moral vision of our ancestors or the forefathers.
Well, I think that vision is basically that each of us would be free to follow our own, as long, you can swing your fist until you hit someone else's face, that we are free to follow, our wishes and to fulfill our dreams. Yeah, and the Constitution's been pretty good about that. And it's worked tolerably well so far. It's certainly been stressed from time to time. But the notion that I hear in some of these questions that, well, the judiciary is extra special and we ought to treat it as something, that only the right type of people can vote for or determine who's going to be a judge. I don't know. It raises the question to me of qui custodes. My Latin's not up to it. Who guards the guardians? Who says who's going to be a judge?
So
I vote with the people.
could I do just a little addendum?
I will yield my remaining time.
Thank you, sir. So it is a common aspect of life that we look to people with subject matter expertise to make the decisions on areas of our lives where you need to have some specialized knowledge, right? So I had to have an operation done a couple of years ago, and we did not conduct a vote of all comers to decide who's going to conduct that operation. I insisted that there be a body of people in this fair nation of ours whose primary responsibility is to determine who is and who is not qualified to cut me open. And That's an entirely natural thing, and nobody's going to argue against that, right? But all of a sudden, when we get to the subject of judges, we all want to have a say, even though 99% of the people have no idea what they do and why they do that. Now, and the only answer I can come up with is the reason people want to have a say in that, notwithstanding the fact that they don't have the training or the experience or the disposition to select judges on a basis that is relevant to the work that they do, is because they think it's a political job. And I've got political ideas, and your political ideas aren't any better than mine, and mine's not better than yours. And so, we'll all get together, we'll decide what a judge is. And so it starts from, I think, it's just an entirely mistaken foundational premise that the work of the court is accessible to anybody who cares to walk into a voting booth and look at a list of names. And it's not.
Thank you both very much. I think we're out of time, Louis.
Yes, we're out of time.
Okay. Thank you all.
Thank you all for attending tonight's debate. I just have two brief announcements. Tomorrow, we'll be having a lunch event with Ilan Werman on Are We Still All Originalists Now? That will be at 12 p.m. in McDonough 201. And then the debate on October 1st, so not next week, but the week from that, is whether the president has the authority to implement tariffs. And we'll have Chad Squitieri of Catholic Law arguing the affirmative and John Vaccioni of NCLA arguing the negative. Thank you.
All right, very good. That was wonderful.
Well,
You guys were terrific.
as a judicial candidate, I'm used to walking into a hostile audience.
I wasn't even thinking that it's the court you were on until I realized, oh, it's the court you were on.
Yeah.
I remember I sent my father, who's also a lawyer, I sent him arguments that was engagement.